Myers presiding.
Good afternoon.
Good afternoon.
Good afternoon.
I'll call the case 0519012004 CR Roberts v. State. And who will be arguing for the appellant
Jeremy Oney. I'm the attorney for the appellant.
and for the appellee?
Carla Ball with the Grayson County Criminal District Attorney's Office.
All right, well, welcome. I guess one thing good about Zoom is that you all didn't have to travel from Grayson County. I'm sure that you've been here arguing before the Fifth Court before, but I'm going to go over the timing. Each side has 20 minutes for oral argument, and the appellant, Mr. Oney, you will have an additional 5 minutes for rebuttal argument. So are you ready to begin, Mr. Oney?
I am, yes, ma'am.
All right.
Thank you. May it please the court. This is an appeal of a conviction for injury to a child, first degree, causing serious bodily injury. There are two issues I would like to address. First will be the sufficiency of the evidence to support the jury's conviction of the appellant for intentionally or knowingly causing the serious bodily injury of the child by her omission. And time permitting, I will address the second point, which is whether or not the trial court erred in excluding part of the testimony of the appellant's expert witness at trial. Turning first to point one, whether or not the evidence is sufficient to prove that the appellant intentionally or knowingly caused the serious bodily injury to the child by her omission. Looking just briefly at the facts of this case, this is about a child who was born on April 19th, 2017. He was a twin. His twin sister died in utero, and the mother carried them both to term and delivered them both on that same day, April 19th. Now, the baby did have some health issues in the hospital, but those were addressed. And ultimately, the child was released to Ms. Roberts. On June 7th of that year, 2017, Ms. Roberts attempted to take the child to the doctor. The clinic would not accept her because the child was not vaccinated. But at that time, she told the doctor that there were no issues with the child. On June 12th, 2017, law enforcement and medical personnel received a call from the appellant because the child was non-responsive. During the course of the investigation, Ms. Roberts told medical professionals and law enforcement that she had fed the child that morning, had laid down to take a nap, and when she woke up, she found him non-responsive, and that's when she called law enforcement. They attempted to do life-saving measures, and ultimately the child was taken to the hospital where he was pronounced dead. Now, based on the facts of this case and how it was indicted, in order for the evidence to be sufficient in trial, the state would have been required to prove that the appellant intentionally or knowingly, by omission, caused serious bodily injury by failing to provide food or medical care, and that she had a legal duty to act. And at trial, pretty much of these, the contested issue was the appellant's mental state and whether or not the omission was intentional or knowing. Now, injury to a child is a result of conduct offense. To say if the evidence is to be sufficient to prove intentionally or knowingly, it must show that she intentionally or knowingly caused the result, which in this case is serious bodily injury, not simply that she intentionally or knowingly engaged in the conduct. For the evidence to show that the omission was intentional, it must show that there was a conscious objection or desire to cause this result. Basically, that she desired to cause her child serious bodily injury. And if it's to be sufficient that she acted or that the omission was knowing, she must have been aware that it was reasonably certain to cause the result. Now, I'm going to address each of these separately, intentionally or knowingly. But at the outset, I would like to state that the state's brief on 2 separate occasions misstates what the issue is in this case. And I'll quote from the state's brief: "The only issue was whether or not the appellant failed to provide adequate food or medical care for Amari Long, which caused serious bodily injury leading to the baby's death." Well, the state's framing of the issue and subsequent argument excludes the mental state at all. And I think that the issue here is whether or not the evidence was sufficient to support the alleged mental states. Let's turn to each one of those and direct look at those. So intentionally, the record is void here of any evidence that Miss Roberts wanted to or was intentionally causing her baby serious bodily injury by her omission. So the record, for starters, demonstrates that she was extremely upset when law enforcement and medical personnel arrived at her house. Clearly, she had concerns. She had previously lost another child recently and was distraught at the idea of something being wrong with this child. There was evidence that she had concerns regarding her ability to produce enough breast milk, and she took those concerns to a family member who was a nurse, and she had begun to supplement her breast milk with formula because of her concerns that she wasn't producing enough breast milk. This was supported by the record in that medical personnel found formula in her home, and she told them at that time during the investigation that she had fed him 2 to 3 hours prior to them arriving, which is consistent with what the medical expert testified to, which is that he had eaten 3 hours or up to a couple of days prior to that. So when you look at the overall actions of the appellant in this case, it's not evidence of someone who was intentionally causing her child serious bodily injury, that she desired or wanted her child to suffer serious bodily injury. I think the record is void of anything that you could point to say that this was her desire. So consequently, to sustain the conviction, the record must show that she knowingly, by her admission, caused serious bodily injury. As you're aware, what that means is that she was aware that her conduct or her omission was reasonably certain to cause the results. Now, the record shows that she did have concerns about whether or not she was producing enough breast milk. And she took steps because of that. What steps did she take because of those concerns? She supplemented her breast milk with formula, and she discussed this issue with her aunt. And I think it's important to note that her aunt is a nurse, and her aunt told her that she just needed to keep trying, keep working at it, and not to stress out, because ultimately that could make the issue worse. So the record is clear that she was taking steps to deal with these issues. But what the record is void of is any evidence that she was reasonably certain that these deficiencies would lead to serious bodily injury. There's no evidence of Amari's appearance leading up to the day that he passed away. Obviously, have the autopsy photos in evidence, but beyond that, there was one photo I believe was undated, and while it showed that he was a small child, I don't think that there was anything there that he was obviously in distress. None of the witnesses.
My understanding is that when, and I think I have it here, that when they weighed the baby after its death, the baby weighed basically 4.5 pounds. And so we're supposed to determine if there's enough evidence that a jury could have come to that reasonable conclusion. And so a 2-month-old baby that's 4.5 pounds, you don't think that's some evidence that just in looking at the child, you might be concerned that there was a reasonable, that you might be concerned that you might be causing bodily harm? And I also want you to answer the question. You said she supplemented, but my understanding was she didn't start supplementing till the day before. Is that correct?
So to answer your questions, I'll answer your second question first. I believe that if it was not the day before, it was in the prior couple of days that she had started supplementing that with formula, correct? The breast milk with formula. Going back to your first question, yes, I do believe that the weight of the baby would have been a concern. And certainly she had concerns and she was addressing these concerns. But where I feel like the record lacks is whether or not it was sufficient for her to know. I think it's important to note that she had previous issues with her children, her prior children. The record shows that she was having a hard time producing enough breast milk. And in each of those cases, she was able to supplement with supplement the breast milk with formula, and there were no issues with her other children. So as far as looking at what her mental state was, whether or not she reasonably believed that this omission was going to cause serious bodily injury, I think it's reasonable that she could have believed that, as she had done with her prior children, simply supplementing with the formula with the breast milk had previously addressed those issues. Now, a couple of other things I think are important to point out.
I wanted to ask one other question to follow up, but not on those that Justice Nowell asked about. You said we have autopsy photographs, but those, you kind of almost indicated those aren't relevant. So let me ask you about that. I thought they were highly relevant. I've never seen a child who had the skin texture of, it looks like a prune. I mean, very, very wrinkled, except a couple-hour-old newborn. And this is about a 2-month-old child. And why are those autopsy photos not representative of what the mother was looking at in the week and the days before the child died?
Well, I certainly would not argue that they're not relevant, and I didn't mean to imply that they weren't relevant. But the testimony was, and I think that it kind of stands to reason that once someone dies, that their texture changes, their skin changes, and things like that. And so I think it may be more relevant to, obviously, his weight and things like that. But as far as what his skin looked like prior to death and after death, I don't think that you can say that, because I think that simply the process of death and what happens when you die would change the skin tone and the things of the baby. So certainly his weight.
You're saying we effectively have no evidence of what the mother was looking at in the weeks and the days, because the testimony was it would take several weeks for this child to starve and get into the condition the child was in. And you're saying we have no evidence of what the mother would be looking at and seeing.
I wouldn't say no evidence, because I think that the autopsy photos, but we don't have any way to decipher from the autopsy photos what effect the child's death had on his appearance in those photos versus what the mother was actually seeing as she was going through this process. Now, certainly I agree with you that the expert testimony and the doctor's testimony certainly was that this was a process over a period of time, and that the body tries to basically sustain itself off of the fat and things in its body as it gets to this position. However, what the record doesn't show is what is the timing of how that would affect his appearance. Was it the day before when she started supplementing the formula when it got so extreme? And it looked like that. Had he looked like that several days? He may have, but the record doesn't demonstrate that. We don't know when that drastic change actually occurred in the child. And so I think it's important to note, although they never were really able to pin down the days when they actually observed the child, the family members who did testify, neither of them testified to having any concerns based on the child's appearance.
When we're talking about, I want to go back to that when you're talking about, so if we take appearance out of it in some ways, taking that small part of that, my understanding is that she was given charts to kind of track things to make sure the baby's getting enough to eat, especially because I think there was an issue of a low blood sugar at birth. So they gave her a chart. So she was supposed to be tracking diapers. She was supposed to be tracking failure to cry, like bowel and urine movement. So again, with testimony that it would take a while for the baby to get to this, that there would be less bowel movements, there would be a failure to cry. And given the background of her having 4 other kids, again, why is this not sufficient evidence for a jury to have come to the place that not looking at these things, not watching these things to a level of that she knowingly could have seen that bodily harm could occur?
Okay, to start with the first part of your question, that is correct. I believe the testimony was that she was educated on breastfeeding at the hospital, and I believe you're correct as far as giving a chart or some form of a way to track that. And I think certainly the results of that could be, and obviously were, she had the concerns. I mean, the record is clear that she was concerned that her breast milk wasn't sufficient in sufficient amounts. And so she did ultimately take steps. Now, I think that when you look at when she went to the doctor with the child on the 7th, a few days prior to his passing, at that time, the doctor asked her, and just to reflect her recollection, so the doctor would not see her, but she just happened to be standing at the reception area when the appellant came in with the child. And so she asked her, "Are you having any problems with the baby? Is there anything that needs addressed?" And at that point, she told her no. So she didn't see. I think that the record shows that while she may have had a concern, she didn't appreciate that it was going to lead to such extreme consequences or serious bodily injury. And that's what the record has to show is that she was reasonably certain that it would cause serious bodily injury, not just that this was causing harm to the child, which she obviously seen that because she started trying to take steps to recollect or to rectify this situation. And so, and even a couple of days prior to the going to the clinic where she was refused, she had been to the OBGYN. And at that point, she had also told the OBGYN, the record was unclear whether or not the OBGYN saw the baby or was just relying on mother's word. But at that point, she indicated mother and baby are doing fine. So if she was reasonably aware that this was going to lead to death or serious bodily injury, she would have had these opportunities to, I mean, she took the steps that she thought she needed, and she could have taken these extra steps if she was reasonably believing that it was going to lead to serious bodily injury. Because it's not what should she have known, it's what could she reasonably know whether or not that this was going to lead to serious bodily injury. Even Dr. Lipscomb, the state's expert, testified that the baby was getting nutrients. Obviously, that he testified and ultimately ended up being an insufficient amount of nutrients. But I think the fact that she was taking these steps and doing what she had done with her previous children is evidence that she wasn't aware that it was going to lead to serious bodily injury. She was taking the same steps that she had with her previous children, and the baby was getting nutrients. It just unfortunately didn't end up being sufficient. So these are the acts of someone, I think the evidence shows that it wasn't someone who was believing that this was going to lead to death or serious bodily injury, because she was taking steps that she thought were appropriate based on the circumstances.
Mr. Oni, would you address these Facebook posts? Aren't those some evidence of her intent?
No, I would say no.
Not to want to keep this child?
I think that there's certainly a distinction between having concerns about whether or not that you can financially and stability-wise support 5 children as a single mother and making the comment, I'm not sure I can keep these child. I mean, I think that comment can be made short of intending on starving your child to death. I mean, certainly she could have been implying that an adoption was a possibility or asking a family member to help her out. But no, I don't think that that's enough of a link to say, okay, because she had concerns about whether or not she could care for a child and keep that child means that she intentionally starved him to death. I don't think that is sufficient in and of itself when you look at the complete record to show that she intentionally harmed her child. I've just got about a minute left. I'll briefly address the second point, which is the trial court abused its discretion in limiting the testimony of the appellant's expert. He wanted to testify and was prepared to opine that the appellant did not indicate any traits or personality characteristics of those typically associated with mothers who kill their children. Ultimately, the trial court excluded that opinion based on the Gallo case, which was cited in the briefs and at trial. The court basically held that Gallo stood for the proposition that that testimony is never allowed. However, under the facts of that particular case, the Court of Criminal Appeals said that the appellant had failed to meet the burden in that particular case that the opinion was relevant and reliable. The court here, I don't think, engaged in that analysis. The court simply said, well, because it was disallowed in Gallo, that it shouldn't be allowed here without engaging in the test setting out in Nano for soft sciences. So I believe that the court erred in excluding that testimony. So we would ask that the court to reverse the conviction of the appellant.
All right, thank you. Ms. Ball?
Thank you. May it please the court, counsel. The primary issue on the first ground raised by the appellant in this case is whether or not the jury had sufficient evidence to look at in the record to believe that Ms. Roberts either intentionally or knowingly omitted feeding the child properly and getting proper medical care for the child, knowing that the child would probably die from that. The primary evidence, though, we've jumped around it, is she had 4 children before this child. And she basically told Chief Sean Johnson that she had not produced enough breast milk in her prior pregnancies and had to supplement them. So this was not an issue this is not some 15-year-old child who has had a baby and has absolutely no idea what she's doing. This is clearly a woman who understood what happens when you don't produce enough breast milk and understood that she had to supplement. Those autopsy pictures, the descriptions by the first responders that the child was sunken in and concave and the skin would not tint, all of those things very clearly were a child that was in the process of being starved to death and dying from malnutrition and dehydration. For her to be able to look at the child, already knowing that there can be an issue if she doesn't produce enough breast milk alone, is enough for that jury to believe that she, at least at bare minimum, knowingly omitted the things that she should have done for this child to keep him alive. On the second issue, I do want to address the case in Gallo. The case in Gallo held that the defense had not shown that the evidence from their expert regarding the characteristics of someone who would commit filicide or would kill their own child had not been proven at trial, and the trial court had not erred. I think that's exactly what happened in this case too. Ultimately, when Dr. Keenan testified, he testified to a number of things. One of the things was that he had based his opinion on his own personal experiences and on some unnamed reports and some other materials that he had observed. He didn't have those with him. He never produced them for the court. He couldn't name them. When the prosecutor got particular with him at the hearing outside the presence of the jury, he asked him, "Are you aware of studies indicating when the risk of homicide for victims is the highest?" He said, "Not specifically, no." He asked, "Do you know what the 5 major motives behind maternal filicide is?" He said, "No, he does not." He went on and was unable to answer many of the questions that should have been raised in the research he had done in looking into filicide. Ultimately, he agreed that there is not enough research into the characteristics of filicide to come up with a set profile. When asked that question, would you agree? The doctor said, that's true. Faced with that, the trial court is looking at an expert who is basing his opinion on certain characteristics set out for filicide that even the doctor is saying you can't prove. It's not a set moment. It's not something set, even for soft sciences, in order for that to be a legitimate opinion. The trial court made its decision that it was not proper under that analysis, and because of that, the trial court did not err. And unless y'all have questions, I don't want to go into the details of the facts that are set out in the first issue, because we set that out in the brief and you don't need me to go back over that. But ultimately, unless you have questions, we will give back the rest of our time.
All right. Thank you. Thank you very much. Mr. Oney?
Just a brief response, Your Honor. I'd like to once again address the issue of the fact that she had 4 prior children. And clearly the state wants to point to that to say that because of that, she should have known. I mean, the mental state is, what would she have reasonably known or believed? And because she had those 4 previous children, those 4 prior children, and she had the same issue with those children, and was able to supplement her breast milk with formula, and everything was okay with those previous children, that just goes to show that she could have reasonably believed in this case that because she was doing that same supplementation, that the child was not at risk of serious bodily injury. And just
you do agree, though, Mr. Oney, that again, we have to look at what evidence was before the jury and could they have reasonably come to that conclusion. So while I understand how you're reading that evidence and then how the state is reading that evidence, that those are 2 different things, but you do agree that the jury could have read the evidence the way the state presented it, or believed the evidence to support what the state's stating versus what you're stating.
That's correct. Obviously, when there's 2 different positions on the reading of the evidence, the jury can interpret however they want, but it's still this court's function to determine whether or not what the jury believed, if the evidence was sufficient to support that belief. And as I previously discussed, I think that the record in this case falls short. And so that's really the only other point I wanted to address. So unless there's other questions with that, I would just again urge this court to reverse the judgment of the trial court.
All right. Any other questions? Justice Now, Justice Evans?
I think they both did a very good job. Thank you all so much.
Thank you, Your Honor.
All right. Thank you
both
both.
very much.
Thank you both for very good arguments, and the case will be submitted on the briefs, the record, and your arguments. We will issue an opinion in due course. Thank you.
Thank you.